So right now it's discretionary, but if she testifies and refers to a single record, then we're going to be back in the spot where I'm entitled to the entirety of her file.
Good morning, this is the time stop for case D190C. We have both parties and their counsel in court. Can we have counsel make your case, please?
Good morning, Your Honor. Richard Schonfeld, bar number 6815 from the law offices of Chestnut and Schonfeld, appearing along with his present.
Brandon Leavitt, bar number 11834, on behalf of the defendant, who's present in court today, Your Honor. Also at our table is my paralegal, Ms. Kimberly Bryant, who will be assisting us today.
All right, you can sit down.
Thank you, Your Honor.
Do we have any agreements on the pending issues today?
No, Your Honor.
But for stipulations on exhibits.
Okay, and that's where I was going next is.
Your Honor, I'd like to invoke the exclusionary rule. I see that someone is logged in under Dr. Monique.
Yeah, we're not, but they can't see her here.
Oh.
We're muted right now. All right, so on plaintiff's exhibits, which exhibits are you guys stipulating to?
We're stipulating to 11, 17, 23,
Don't go that fast. 11, 17, 23.
26, 27, 28, 35, 40, 55, 61, 64, 66, and 67.
Can you go through that one more time?
Sure. 11, 17, 23, 26, 27, 28, 35, 40, 55, 61, 64, 66, and 67. And you want me to read in the ones that you're stipulating to, or do you want to do that?
You are welcome to.
So the plaintiff has agreed to stipulate to defendants exhibits A through K, M, O through R, T through X, double C, double D, double G, double I, and double J. Would you like me to read those again, Your Honor?
Probably, just to make sure we got them right.
One more time. A through K, M, O through R, T through X, double C, double D, double G, double I, and double J.
You concur, Mr. Schonfeld?
Yes, Your Honor.
All right, so with that, what I'd like to do is, still looking at the issues, I think that we start with each of you having 6 hours for presentation of evidence. So that'll get us, I'd like to be done with evidence by tomorrow afternoon, and then save the next Wednesday for closing, any housekeeping, and rendering the decision. If we can have that goal in mind, I know you guys ask for more, so if you need more, I'll give it to you, but I think if we have that goal in mind, we might be able to meet that goal. Any questions, objections to that?
No, Your Honor.
No, I think we can do that.
We do have one issue to
Yes.
address before we start.
Go ahead.
Your Honor, when we were here for the calendar call, we addressed Dr. Monique testifying. The court may recall I objected to the late disclosure. The court overruled that objection. I then said that I wanted her entire file produced as opposed to piecemeal, which is what has been produced. In response to that, the defendant produced a 4-page summary from Dr. Monique, wherein she states that she is not willing to provide her clinical notes. Instead, she summarized her clinical notes. So I'm going to again move to exclude Dr. Monique. Under Nevada revised statute, if a witness reviews records in anticipation of testimony. The court has the discretion to require them to produce the records. So I would ask that if she is going to be permitted to testify, that the court order her to produce complete records of her treatment, progress notes, and communications with the parties. And then the statute also says that if she references her records while she's testifying, we're entitled to production of the records. I don't see a way that she's going to be able to testify without this material becoming a necessity in terms of production under the Nevada revised statute. So I think we need to address that before she testifies, because if she's going to continue to refuse, she should be excluded.
2 points of response, Your Honor. Again, we did give opposing counsel several of the records that my client was in possession of. Second, the child's current therapist, Dr. Shannon, has produced 0 of the files, so we have none of their progress notes. And again, it's a little disingenuous to want to exclude one when the one that they're relying on hasn't produced their file either. So for intents and purposes, again, the court does have discretion, and it makes sense that both of these experts, therapists, I suppose, are able to testify as to the child's best interest and as to the therapeutic interventions involved. Again, you can't exclude one without the other because they don't have medical records either.
Well,
So,
one, I asked for production, and the defendant said they would produce them, and the doctor's refusing. The other, it's never been raised, and I don't know that he's going to refuse. He's a subpoenaed witness, so we can address it when he gets here, but I doubt that he's going to refuse, whereas this treating person is refusing.
And the problem is that if she needs to, and typically we would expect that, and it's especially been a while since she has treated the party's son, that she would have to refer to notes to refresh her recollection. And both of you are entitled to have those then, if she's referring to them to refresh her recollection. So, and that would be the same for the current therapist too. Although the current therapist may not need to refresh as much. So, I mean, and not here, even if she came in person and had her file, we can even make copies of it. We can work around certain things, but she's not even here in person.
no, she's here via video, but I understand what the court is saying.
So what's your offer of proof, Mr. Leavitt, on what you believe she's going to testify to?
She's going to testify to the therapeutic interventions of the child between November of 2021 to approximately March of 2022. I think she met with the child approximately 8 to 10 times. She did detail in her summary all of the interventions that she utilized, the methodologies that she utilized, and made her findings and recommendations in her summary. Thus, again, the summary is extremely dispositive for the court and accomplishes what Mr. Schonfeld's concerns are, because they're addressed therein. This is a tactic to avoid a alternative point of view as to mom's parenting. They don't want this therapist to be able to testify. And again, that's not what the rule is designed to accomplish. Your Honor, again, you are required to accomplish the best interest of the minor child. This is incredibly dispositive in allowing you to do that.
Well, Your Honor, at the end of the day, if she produces her records, then the court's already ruled she's permitted to testify. If she refuses to produce the records, which clearly she has reviewed in anticipation of her testimony because she prepared a summary of them and produced that, I'm entitled to see the records for cross-examination purposes. So there is a solution. We can get her, she's apparently on the video, we can go live and have her address the court and whether or not she's willing to produce her records. She's not going to testify until tomorrow. I don't know why she's here. I'm going to move to exclude that as well. But given that she's already on the Zoom feed, we can address this issue, and if she refuses to produce the records, then the solution is simple. She gets excluded. If she produces the records, let me get them today and I'll cross-examine her tomorrow.
Mr. Leavitt, you subpoenaed her,
We did, Your Honor.
and what time did you subpoena her for?
To testify
I mean,
and to...
I mean, what time and date did you tell her to be here?
We didn't know when she would, in theory, testify, so she's available all 3 days of trial. We did communicate with her yesterday evening, and she knows that the testimony for her will occur tomorrow. So she is standing by, but she does understand tomorrow will be her testimony.
All right, and Mr. Schonfeld, what is the exact NRS site?
For the,
Yeah, you said
using the records, give me
Yeah.
court's indulgence for 1 second.
somewhere in 49, 50, 50.
It's in 50, Your Honor.
Somewhere in there, right?
It's in 50, I believe. Let me find it.
And again, Your Honor, if there's even a question, then, you know, Shannon should be excluded as well because we don't have their file either. So if they're going to produce Shannon's file, then fantastic, because again, what's good for the goose is good for the gander.
50.125, Your Honor. And all I can do is ask Shannon Smith to bring his file with him.
That doesn't give me an opportunity to review the records and or, you know, vet them and or cross-examine based on them.
He's a subpoenaed witness, Your Honor. I'm happy to send him an email. I'll CC opposing counsel, and we'll say that the court, if it's court ordered, the court would like the records produced. I don't think he's going to be resistant to that, whereas this witness is.
Well, again, Your Honor, it reeks of trial by ambush to bring the file day of, and I have no opportunity to review it beforehand while he's on the stand.
Well, let me ask you both an important question here. Did either one of you subpoena the records?
I did not, Your Honor. I subpoenaed the witness.
Again, we did the very same thing, Your Honor. We subpoenaed the witness.
Well, I guess the answer would be that I may not allow her to refresh her memory, including using the summary. If she's unwilling to provide the records, I want to use them to refresh her memory.
The difference, Your Honor, is that, again, we did produce several of the records from this therapist to opposing counsel. So they may not have a complete record, but they have a substantial amount of that record.
And that's the problem. Whereas, you know, they're trying to conflate the issues. Dr. Smith will likely produce his entire file, but we don't have any records from Dr. Smith, neither party, so we're on equal footing. Whereas Dr. Monique has provided some records and refuses to provide the complete file, and 2 days ago approximately, she summarized the entirety of her records. So she has clearly reviewed her file in anticipation of testimony. NRS 50.125 expressly states that if a witness reviews material in anticipation or preparation for testimony, the court has the discretion to require it to be produced. It then says if the witness utilizes records while testifying, then we're entitled to all of it. So right now it's discretionary, but if she testifies and refers to a single record, then we're going to be back in the spot where I'm entitled to the entirety of her file.
Or you exclude both of them from testifying.
There's no basis for that.
Well,
I mean,
to avoid, you know, trial by ambush and fairness, I think that's not true.
I was told, and so was Your Honor, at calendar call, that we would have the entire file.
Yeah, and again, I hadn't spoken to her at the time, and I don't control her professional independence in providing her records. I don't get to do that.
then you guys didn't take depositions of these witnesses.
No.
So,
Well, the court may recall one more thing. I noticed Dr. Smith, Shannon Smith, months ago.
Yeah.
We got Dr. Monique on the last day of discovery, 20 days after the deadline. So I'm the one that's being disadvantaged here. That's how this whole thing came up. She should have been excluded based on the prior court order saying 21 days before the close of discovery, you produced your witnesses. Then I could have subpoenaed her for her records. However, on the last day of discovery, I couldn't do anything. Defendant could have subpoenaed Dr. Smith for his records. They didn't. They had notice of him for months.
He also could have subpoenaed her that day, but chose not to do it.
he couldn't do, that's the discovery cutoff. He couldn't send out even a 7-day notice and then send out the subpoena. And that, I mean.
We would have stipulated.
I mean, it's.
We would have stipulated. This isn't rocket science. Again, Nance requires you to consider the best interest of the child and all factors relevant to doing that.
There's an easy solution, Your Honor. Order her to produce her file, and if she refuses, then she gets excluded.
Are you going to have her come in person tomorrow?
She's out of the jurisdiction. She's doing this on vacation, for Your Honor.
Okay.
Is she getting paid?
No, not to my knowledge. Well, is she?
Yeah, she's not
Her hourly rate, apparently.
She's not a designated expert, but she's getting paid for her testimony.
All right, let's turn on the, let me see if we can get her.
Yeah, Shannon wasn't disclosed as an expert either.
I'm not paying her.
Okay. Yeah, we did receive an email he's requesting payment.
I didn't get that, but apparently my client just told me he asked for payments for both Doug and.
Yeah. Yes, that's true. So he's asking for compensation as well.
Dr. Monique, are you there with us? Hi. This is the judge on the custody case regarding the party's minor child. The attorneys are having a debate over whether or not you've produced your whole file and were willing to do that. I know Mr. Leavitt is planning on you testifying tomorrow during his case in chief, his time. So you provided a summary of your records, but not provided the actual clinical notes. And they've argued that you're unwilling to provide those.
Correct, I want to exercise clinical discretion in limiting the scope of what's provided to maintain the disclosures made by the minor in confidence.
Yeah, and it's a hard situation, but I have to make sure the trial is fair. And if you went and reviewed your records and gave a summary of them, and you're gonna use that summary that you made from reviewing your records, then both parents are entitled to the whole set of it.
Okay.
So they're entitled to see it so that you can be proud. It might not make any difference, but if there's something in there that Mr. Schonfeld wants to cross-examine regarding, I have to let him do that. And I know you're not here in the jurisdiction, so you're not coming in person, so we can get the file and copy it and things like that.
Right, it's all available electronically. I can do that, or I guess how would I submit all of it? From this file electronically?
Yeah, that's a question. Normally, I say you can just email them, but
We can do it via Dropbox. That's an encrypted way of doing it to secure and ensure the confidentiality and protection of the information. There's other mediums to accomplish that, but if she's capable of downloading them or uploading them rather, there's methodologies available online to be able to do that. It wouldn't require her physical presence to copy the file.
and do you have that ability?
I do.
So you could do a Dropbox and then email both counsel the link to that? It would be a secure. I don't want you to violate your HIPAA requirements on making sure that you're sending it securely. But if you
Yeah, no, I'm familiar with Dropbox. I've used it for other cases.
okay, so then if you could do that today, and then what time did you tell her tomorrow you're gonna have her testify?
We didn't have a time because I wasn't sure how today was going to flow, so she's on standby, but if we want to try to dial in time certain, that certainly will accommodate her schedule, and I would appreciate that.
Right.
Yeah.
I'd like-
Also, Judge,
Go ahead.
sorry,
Go ahead.
I'm testifying in another case in another court tomorrow. They said around 10 a.m.
So what if we had you specifically testify, if we had to take you out of order at 1:30 tomorrow?
That's
Would
fine.
that work for you?
Yes.
Yeah, that's
Mr. Schonfeld, no objection to
No
that?
objection, Your Honor.
that's
Okay, so
satisfactory.
then we'll plan on you being available on Zoom. It'll be the same Zoom link you've got for today, tomorrow at 1:30.
Your Honor, I would just ask Mr. Leavitt's office to send her an email with my email address, because I don't think she has it.
Yeah.
Yeah, happy to do that.
Can you do that right now? So that-
Doing it as we speak.
Okay, and then we can have you send the records to both counsel through the Dropbox, and then that'll solve any problems, and we'll have you specifically testify tomorrow at 1:30.
Perfect. Thank you so
All
much.
right, thank you for your time.
Okay. Thank
And
you.
again, Your Honor, we're also asking again, now that they're going to get the records, we'd ask for Dr. Shannon's records as well, please.
And did you have a specific plan on when he was testifying?
Tomorrow morning.
Tomorrow morning, okay.
So I can, at the break, I can send him an email and let him know that the court has asked that he produce his records to both defense counsel and plaintiffs.
It'll help it flow a lot better for both of you, although, so the record's clear, the defendant had the ability and had the time to subpoena those records. Because they have to comply with the subpoena or then end up in front of the discovery commissioner if your witness didn't comply with the subpoena for documents. Because both parties in this case have the right to waive the HIPAA requirements regarding their minor child. And so any provider would have to provide their records with that proper HIPAA release. So
I suppose that this will probably be much ado about nothing, since I don't know that either of us will cross on the records, but we'll see.
well, it may be very limited with Dr. Monique. If you said that she stopped treating in 2022, that would be 3 years ago.
That's right.
So I don't know how helpful that is, but you have the right to spend your time on that, so we'll do that. Any other housekeeping we could, so we resolved those two things, but any other housekeeping?
Not that I'm aware of, Your Honor, thank you.
All right, so we can go to opening statements if you guys want that, or,
Your Honor, we've agreed that we're going to waive openings and just get right down to business today.
all right, we ready to call first witness then?
Yes, Your Honor, I'm going to call.
Okay.
Yeah,
Raise your hand, standing, face the clerk.
You just solemnly swear the testimony you're about to give in this action shall be the truth, all the truth, and nothing but the truth, so help you God.
State, spell your name for the record. Mr. Defendant in this action, correct?
Yes,
And obviously you understand why we're here today, correct?
I believe so.
What's your understanding of what Ms. means by way of this pending motion?
I believe that she is seeking sole legal custody in part or whole, and some form of primary physical custodial schedule.
Mr. testified at a deposition in this matter recently, correct?
Yes,
And you testified that you believe that you are effective at co-parenting?
yes,
Is that still your belief?
yes,
And do you understand the difficulties that it can cause a minor child if the parents are not effective at co-parenting?
yes,
You're aware that in October of 2021, specifically in an order dated October 13th, you were found by the court to be passive aggressive, correct?
I don't know if there was a finding.
You're aware that that's in the order, correct?
I'm not certain.
Okay, take a look at Exhibit 69 in one of the binders in front of you.
Richard, additionally, we only have in your book up to 67. Thank you, thank you. Very much.
Do you have that order in front of you?
I believe so. Exhibit 69, order after hearing on October 13th, 2021.
Okay, and you recognize that to be a court order that was entered by this court, correct?
I believe so, yes.
Take a look at page 4 of that order. At line 19. You see where it says plaintiff asked something that may seem perfectly normal to her, but dad may be passive aggressive, not respond, and do exactly the opposite.
The question is, do I,
It's line 19 on page 4.
The question is, do I see it?
Yes.
Yes, yes.
Okay, so do you recognize that the court made a finding that there are circumstances in which you are passive aggressive, you do not respond to misbehavior, you do exactly the opposite of what she's requesting?
Again, it's the word finding that I don't know if it's dicta or finding is basically what I'm unsure of.
Okay, but you see it there black and white in an order signed by this court, correct?
I see it, yes.
Okay, so how about we call it this? It was the judge's opinion as of the order of October of 2021 that there are circumstances in which you may be passive aggressive, not respond to misbehavior, exactly the opposite of what she's requesting, correct?
I believe so, yes.
You don't agree with that characterization that you're passive aggressive, do you?
No,
You don't agree that oftentimes you don't respond to misbehavior?
I'm sure there are times that I do not respond.
Do you think that that's a practice of yours, not responding when requests through OFW?
I don't know if I would say it's a practice.
What would you call
An attempt to minimize conflict.
it? So it's intentional on your part that there are times where communication through OFW and you won't respond, correct?
I'm sure on occasion, yes.
It's not an inadvertence. In other words, it's not that you missed the message. You intentionally declined to respond, correct?
There may be times that it's one or the other.
But you do agree there are times where you are intentionally declining to respond to an OFW request made by Ms.
Yes,
And there is a protocol in place where there's supposed to be weekly communication where you and Ms. The other party a few questions, correct?
yes.
I'm going to ask you to take a look in the other one of my binders at exhibit number 2. Do you recognize that to be a court order from January 2023?
Yes,
So roughly a year and a half after the court order we just looked at in Exhibit 69, correct?
you said roughly a year and a half?
Roughly a year and a half.
Yes,
And take a look at page 3, paragraph 7, line 25. You see where the court noted that you bring the plaintiff to court over petty things, and because plaintiff has an attorney, she is subject to incurring attorney's fees. See
sorry,
that?
the line again, you said page 3?
Yes, page 3, paragraph 7, line 25.
The court notes that defendant brings plaintiff to court over petty things, and yes,
So that was a notation by the court in an order that the court felt you were bringing this over petty things, correct?
yes,
And in reality, you were causing this to bring issues to the court over petty things, correct?
no, I don't think so.
Okay, wasn't it you to court on that occasion related to finding a dental provider that accepts insurance? Oh, sorry, you did bring this on that order, did you not?
I filed the initial motion, I think before the court date. I also filed something else that said that the issue had been resolved.
Okay, but the court found that you brought this court over something petty, correct?
Again, it's the word finding, but it's in the order, yes.
The court noted that you
Yes.
brought court over something petty, correct?
Yes,
Let's turn to some of the other issues that Ms. comes to court on. You're familiar with Ms. have a passport so that she could take him on vacation out of the country, correct?
I believe so, yes.
And do you remember in 2021, you and Ms. parenting coordinator?
Yes,
And the issue was brought to the parenting coordinator for a decision that you to sign a consent form so that she could get a passport and take Nicholas out of the country on vacation, correct?
I believe so, yes.
And you refused, correct?
I refuse to sign a
You
consent
refused to
form.
sign a consent form and permit passport.
I don't know if I would say refused. I think I said that it wasn't necessary.
You would not sign a consent form for passport, am I correct?
Yes,
Even though the parenting coordinator's decision was that you should sign the form and
I believe so, yes.
okay. And as a result of that, Ms. filed a motion with the court seeking an order that she be permitted to get a passport without your consent, correct?
I wouldn't say that she had to file the motion, but yes, I recalled that motion.
And you understood that the reason Ms. that relief is because she wanted to take your son on a vacation, correct?
I don't know if it was the case at that time, but I recall that in general that Ms. to travel internationally with.
You don't find it to be culturally stimulating for a child to be able to see other countries and other cultures?
Objection calls for speculation.
How he feels.
So sorry, repeat the question, please.
You don't believe that it is culturally stimulating for someone such as son to be able to experience foreign countries and foreign cultures,
I believe that it could be culturally stimulating, yes.
yet you would not permit Ms. in 2021 to get a passport and take, correct?
Oh. Again, I dispute the characterization of the method, I guess, but I wouldn't say I refuse to allow her to get a passport.
Do you understand that without a court order and without your consent, Ms. be able to obtain a passport for?
Without one or the other,
Correct.
yes, I believe that's the case, yes.
Correct. So she would either need you to sign off on the form or she would need a court order. Correct?
Yes,
But with you standing idly by, she would not be able to secure the passport, correct?
I believe the parenting coordinator could have written the decision for a court order, but I'm not sure.
Didn't the parenting coordinator write the decision that you should sign the consent form for the passport?
She wrote the decision that I should sign the consent form.
And you still would not sign the consent form?
Yes.
Okay. And so then, Mr. Court, and I'm going to ask you to look at Exhibit 69. This was the one we already looked at. This was where the court ordered that Ms. could in fact get a passport, correct?
I've got to find the exhibit book real quick.
Page 5, paragraph 5. It's the whole paragraph.
Okay, I see, page 5, paragraph 5.
Right, do you see where it starts on line 12? With regard to the passport, that was within the parenting coordinator's decision,
I see that, yes.
and that was the court referring to, the parenting coordinator had the authority to decide that Ms. would secure a passport for.
I believe so, yes.
And you lodged an objection in court under federal law. Do you see that?
I see that, yes.
And the court then determined that it would be appropriate and in fact ordered that Ms. was permitted to get a passport. She had the sole authority to obtain the passport for your signature, correct?
Yes,
The court also found that Ms. in possession of the passport, correct?
yes,
The court also ordered that as long as a parent gives timely notice of a trip out of the country and there is no good faith basis to object to the proposed trip, the other parent is required to sign a letter authorizing the out-of-country travel. Do you see that?
yes,
Then the court noted that a reasonable objection would be travel to a location such as one that's on the do not travel list. That would be a reasonable basis to object to the travel, correct?
yes,
And again, this order was November of 2021, correct?
yeah, it's stamped November 1st, 2021.
Okay, Your Honor, I know court orders don't have to be admitted, but for purposes of having a clean record, I am going to move to admit Exhibit 69.
Any objection?
I mean, technically, this is already part of the record, and I don't know that you can, but if the court is determined to do so, that's all right, I suppose.
69 will be admitted.
You were aware of the existence of this order when it was entered in November of 2021, correct?
Yes,
How many times has Ms. Fiore filed a motion after that related to the ability to travel out of the country with?
I'm not sure, I think twice.
And that's because she requested travel and you refused to sign the consent form, correct?
No, I don't think so.
Okay, what's your belief as to why Ms. two separate motions requesting the ability to take the country after the order from November of 2021?
It was a combination of what I would call miscommunication between myself and plaintiff's counsel, and a request for the consent plan to just specify on which date, which country.
Okay, well, let's start with the England and Spain. Do you remember that Ms. motion seeking a court order granting her permission to travel with England and Spain from June 24th, 2022 through July 18th, 2022 without you having to sign a consent form?
I vaguely recall. I believe that happened, yes.
Okay, and you understand that Ms. filing the motion requesting that relief had informed you that she wanted to take England and Spain from June 24th, 2022 through July 18th, 2022, correct?
I believe she made that request along with some other requests with other countries and dates.
Okay, and you would not sign the travel form? I'm trying to understand your testimony. Because she didn't specify in that time frame of June 24th to July 18th what days she would be in Spain versus what days she would be in England?
That's part of it, in addition to the beginning and end dates of the trip were not specified as to when they would be.
Okay, do you remember looking just a couple minutes ago at Exhibit 69, where the court had ordered that as long as a party gives timely notice and there is no good faith basis to object, that the other party is required to sign the consent form?
Yes,
Okay, and a reasonable objection would be, for example, a country that's not, a country that is on the do not travel list, correct?
Objection calls for a legal conclusion.
That's what the court order says.
Reasonability is a
Page
question.
5, line 21.
Again, the court has to determine what is reasonable or not.
Overruled.
Do you see the specific language from the court? A reasonable objection would be if the proposed travel is to a location that is on the do not travel list?
I believe that that's an example of a reasonable objection, yes.
Okay, and you would agree with me that at the time the request was made, either Spain or England was on the do not travel list that is adopted by the State Department, correct?
I don't believe that they were on the do not travel.
Okay, so your alleged reasonable basis was because although Ms. the date range that she was going to travel and the countries that she was traveling to, she didn't specify the dates she would be in either particular country?
Again, I'm not sure if I understand the question, but in part, yes. I don't think I said I would not sign a consent form. I think I said I would sign a consent form like that.
Okay, take a look at Exhibit 70 at page 2. You would agree with me, are you there?
Exhibit 70, page 2, yes.
You would agree with me that Ms. filed a motion seeking a court order permitting her to take that travel with Nicholas, correct?
Yes, I believe so.
Okay, and your testimony is that, if I'm understanding it correctly, that you would have signed a consent form?
Yes, that's my recollection, yes.
Then why at paragraph 2 on page 2 did you request an evidentiary hearing on Ms. motion?
Why on page 2?
Page 2, numeral 2, it says defendant's request for an evidentiary hearing is denied. Do you see that?
I think your exhibit is correct.
Exhibit 70.
Yeah.
Page 2 of the order, not the notice of entry. Oh.
Sorry, you're going to have to give me, sorry, please. give
Above
me-
the judge's signature line. Do you see where it says defendant's request for an evidentiary hearing is denied?
I see that, but I don't know if it's related to,
Oh, the judge was denying some other request for an evidentiary hearing?
I don't recall, but
Okay, but you do see this is on the first page of the actual order. Order granting plaintiff's motion for an order permitting the minor child to travel with Gina Spain, correct?
I see that.
And the judge granted motion permitting her to travel with the minor child to England and Spain without a written travel consent from you, correct?
Yes,
And in that same order, the very next paragraph, it says defendant's request for an evidentiary hearing is denied.
what's the question? Do I see it?
Yes.
Yes,
But your testimony is that you believe that might be related to some other request for an evidentiary hearing.
I don't recall.
And then you testified that you recall there was another time that you sought court relief related to being able to travel with your son out of the country, correct?
I believe so.
Do you recall what trip that was for?
I recall, I'm guessing a little bit, but I recall, I think a trip to Italy?
Okay. Before I get there, Your Honor, I'm going to move to admit Exhibit 70.
An objection, again, it's already part of the record, but if the court is inclined to do it, then.
Exhibit 70 will be admitted.
I ask you to turn to Exhibit 3.
So,
Let me know when you're there, please.
okay, I believe I see Exhibit 3.
Okay, Exhibit 3 is a court order dated May 18, 2023, correct?
Yes, that's the stamp, yes.
All right, and this says order granting plaintiff motion for an order permitting the minor child to travel out of the country without a travel consent from non-traveling parent. Do you see that?
Yes,
And you understood this motion because you once again refused to sign a travel consent form for her to take the country, correct?
I can't speculate as to her motivation for filing the motion, but I don't think I refused. I think I made a similar request or request for specificity or something else. I don't recall exactly, but I do recall saying that I would sign a request form.
Do you see here where on page 2 of the order it says plaintiff's motion is granted? The court hereby enters a standing order that permits either parent to travel outside of the United States with the minor child during their custodial time and without a travel consent from the non-traveling parent. Do you see that?
Yes,
You've never taken, have you?
I have not. I've made a request to.
Okay, well, you have an order that would permit you to do that, right?
But I would need the passport.
You've never sought court relief related to any such request, have you?
I don't believe so.
So the orders that we've looked at so far related to travel out of the country were orders that were generated as a result of court relief related to travel, correct?
Yes, that's my understanding.
And this order was in May of 2023, which is when looking at the original passport order of October of 2021, moving closer to 2 years now, right?
I think the
19 months, roughly?
passport order was in 2021, and I'm not sure which order you're referring to. And then the other the other order permitting the first trip was in 2022, I think, I'm guessing.
Right, so 1 year after, and then another year after. Had to seek court relief to be able to travel with Nicholas out of the country, correct?
I wouldn't say she had to seek court relief, but
She did seek court relief.
yes.
Okay. And so that's just related to being able to take your son on a vacation out of the country to places that are not on the do not travel list, correct?
As far as I know, yes.
Okay.
I don't believe they're on the do not travel
And
list.
she sought court relief 2 years in a row, correct?
She sought relief 2 years in a row, yes.
And just so I'm clear, your alleged good faith basis for refusing is because you didn't have specifics as to the dates upon which the specific countries that you were aware he would be in, correct?
Again, I wouldn't say refuse. I requested that modification and said that I would sign that travel consent.
Do any of the orders we've looked at so far related to travel out of the country require this to give you the details that you're stating you requested?
The question is, do any of the orders say that?
Yes.
I believe there's an order regarding travel in general that says that we need to specify those details.
The dates of the travel and the countries where you're going to go to, correct?
I believe so.
In your position, even though the court rejected it, is that stating that you're going to go to England and Spain from June 24, 2022 through July 18, 2022 is not satisfying that requirement?
I don't think it satisfies the previous order, no, but I wouldn't have required satisfaction of the previous order anyway.
You also understand that Ms. will not be in a position to give you an actual itinerary, a booked trip itinerary, until she knows that you're either going to sign the consent form or the court's going to permit the travel, correct?
Well, I didn't request an itinerary. I also believe I specified that if the dates were to change, I would be willing to sign off on a new travel consent form.
Because you've been so cooperative with the travel up until that point in time, right?
Objection, Your Honor, argumentative.
What's the question again?
You would agree with me that you weren't very cooperative with Ms. either of her 2 international travel requests, correct?
I would say I attempted to cooperate.
All right, let's move to medical issues that have arisen, treatment issues. Going back to the October 13, 2021 order, which has been admitted as exhibit number 69. And when I say October 13th, the actual order is November 1st, 2021, but it's the order after the October 13th, 2021 hearing. You understand that, correct?
Sorry, I didn't, what you were saying. You said exhibit 69?
Yes.
Okay.
Page 8, line 13. Sorry, line 10, number 13. Do you see where the court stated, with regard to therapy for the court finds that it would help him to have somebody independent and trained who would be able to be a safe place for him to talk about the stresses he is under. Do you see that part?
I see that part.
Says the court therefore grants plaintiff's request that therapy. Do you see that?
I see that.
Okay, so plaintiff being misfiled a request of the court for permission to enroll in therapy, correct?
I believe so.
And you were opposed to that request, correct?
I don't think I was opposed to the request, but I am not certain.
Isn't it true that after this court order was entered, Ms. that Dr. Shannon Smith be the therapy provider?
I don't know how to answer the question. That did occur after this order, but he was not the first provider that Ms.
Okay, take a look at exhibit number 5. I think what transpired, and correct me if I'm wrong, is therapy started perhaps with Dr. Monique, and then when Dr. Monique stopped providing those services, you and Ms. upon a new therapist. Is that accurate?
The question is that accurate? Not exactly.
Okay, tell me where I'm not accurate.
We started services with Dr. Monique. As far as I could understand from her messages, Ms. fired Dr. Monique, and after that, Ms. proposed or insisted that Shannon Smith be therapist.
Okay, so let me unpack that. Isn't it true that Dr. Monique informed both you and Ms. writing that she would no longer be providing the types of therapy services for one-on-one counseling that she had been providing as of, I believe it was March, a couple months later? She would no longer be providing those services.
Objection assumes facts not in evidence and calls for hearsay.
Overruled as to the facts on evidence. I mean, he has to, he remembers why it's cross-examination,
The
so.
black binder, the
Small one?
the small one. It's just easier for me to find it.
I'm sorry, the question again?
Isn't it true that Dr. Monique informed both you and Ms. writing that she would no longer be providing those types of counseling services?
An objection, Your Honor, calls for hearsay.
Overruled.
She informed us, excuse me, Dr. Monique informed us at some point that she would be transitioning to providing either only or mostly court-ordered therapy.
I'm going to ask you to take a look at Exhibit 72. Okay.
Yes.
I'm just going to ask you if this refreshes your memory. That base number 1600, bottom right-hand corner,
Sorry, the base number again?
1600?
Again, objection, Your Honor. This was produced last night outside the close of discovery. It also calls for hearsay.
Your Honor, this was produced after the court overruled the objection to the late designation of Dr. Monique, and after Mr. Leavitt advised both the court and me he would produce the entirety of the record, and after Dr. Monique refused to produce the entirety of the record. So we had to supplement the record.
Okay. And you can cross-examine and or refresh recollection from any document, including a napkin. So he hasn't offered it yet to be admitted. So I'm going to overrule the objection as premature.
Document refresh your memory that on or about February 5th, 2022, Dr. Monique advised you and Ms. that she was accepting a new role and will be transitioning all non-court-ordered transitioning to non-court-ordered families and children by March 31st, 2022.
So the email wasn't sent to me, and everything was produced at the previous order to show cause hearing?
Is your testimony that you were not given notice by Dr. Monique in or around February of 2022 that in less than 60 days she would not be treated, she was no longer doing court-ordered families?
Again, this wasn't sent to me, but my recollection is that that was the case.
Okay, so when you said that Ms. hired Dr. Monique, it was during that less than 60-day period of time after you and Ms. advised that Dr. Monique would no longer treat, made the decision to stop bringing, correct?
I'm not sure about the time period, but approximately around there. I'm not sure if it predated or postdated the information that she was transitioning the practice.
And then after you and Ms. advised that Dr. Monique would no longer be treating, Ms. proposed Dr. Shannon Smith, correct?
I'm not sure exactly when, but at some point, Ms. Fury proposed Shannon Smith. Yes.
Well, if you look at the court order at exhibit number 5, there's an order regarding therapy where the court ordered 6 consecutive weeks of therapy with Dr. Shannon Smith, and that was dated March 14, 2023, correct?
Yes, I see that, yes.
And it was related to a hearing that took place on February 21st, 2023, correct?
Yes.
Okay, so beginning of February of 2020, so in February or March area of 2022, Dr. Monique says she's not going to be treating.
I don't think she said that.
She said she was going to be transitioning to non-court ordered families, right?
I guess it's unclear to me if qualified as a court order.
Why do you think she would send you? Do you have a understanding or a belief as to why the therapist would send an email saying I wanted to start this email by allowing me the opportunity and pleasure to serve you and your child. I hope you have found the counseling work we've done fruitful and helpful. I'm accepting a new role.
Objection, Your Honor. Move to strike. This is, you can't read this into the record. If he's going to offer it, then he can, but this is improper.
Repeat the question, please, sir.
Thank you, Your Honor. You understood, I'm going to rephrase it, you understood that Dr. Monique had sent you, or at least Ms. you gained knowledge of it, notice that she would be transitioning out of transitioning out of court-ordered to non-court ordered families, correct?
I saw the email that was produced, that was to Ms. Says that, I believe, yes.
Okay, and you communicated with Dr. Monique about that, didn't you?
I believe so.
So you did have an understanding that the reason she was giving you that notice is because she would no longer be in a position to treat.
I wasn't sure, but that's certainly possible. Yeah, I could certainly understand that that would be the case.
It would certainly seem to be the context of why the message was sent, correct?
I believe we received like several update emails from Dr. Monique that were not specifically addressed to us, but concerned her practice, but I understand that that could be the case.
Okay, and then thereafter, Ms. proposed Shannon Smith, and you would not agree, correct?
I actually don't remember.
Well, you see at Exhibit 5 that there's a court order regarding therapy for the minor child.
I see that.
And it says that the minor child shall attend 6 consecutive weeks of therapy with Dr. Shannon Smith, and it provides his office address, correct?
Yes, it says that.
Is it your testimony that you were agreeing that Dr. Shannon Smith would treat?
I really cannot remember. I remember saying something at the court hearing that my concerns were not his credentials, but I really cannot remember.
And the court order required that you and Ms. fully split the cost of therapy with Dr. Shannon Smith, correct?
Yes,
Isn't it true that after this court order was entered, you delayed in permitting therapy with Dr. Smith?
I don't think so.
I'm going to ask you to look at exhibit number 8. And Your Honor, as an offer of proof, I'll get this into evidence through my client. There are emails between Shannon Smith and my client. So I'd like to at least ask questions of the witness regarding these emails, and ultimately, if they're admitted, then there's no issue. If they're not admitted, then the court can strike this portion of the testimony.
Okay, but, sorry, tell me what exhibit you're,
Number 8, there are emails from Shannon Smith to Ms. Mr. wrote these at your deposition. Do you remember that?
Mr. I'm sorry, I apologize. I don't recall if we talked about this specific email.
Okay. So the first page is an email on May 10th, 2023, where Ms. writes to Dr. Smith, hi, did you get in touch?
Again,
with
Your Honor, move to strike. You can't read it into the record unless it's been admitted. This is improper.
Well, Your Honor, I've already made the offer of proof it's going to be admitted into evidence at some point, either through Dr. Smith or...
Again, then you can question him or them at that time, but this is improper to read it into the record now.
so what is your question for this? Is he right, you can't read it into the,
All right, let me ask this. Are you aware that by May 10th, 2023, Ms. attempting to coordinate for you to communicate with Shannon Smith so that therapy with him?
That date, I really don't know.
So you don't know when Ms. reached out to Shannon Smith?
Not exactly. I know, no, not exactly.
You did not want therapy, true?
Not true.
Is it your testimony that you did in fact want Nicholas to attend therapy back in May of 2023?
So the question is, in May 2023, did I want to attend therapy?
With Dr. Smith?
I believe so, yes.
And as of today, do you believe that it's in interest for him to attend therapy?
Yes.
Is it your testimony that at no point in time between May of 2023 and the present that you felt attending therapy?
That he shouldn't be attending therapy?
Was there any point in time between May of 2023 and the present that you did not feel that therapy?
I don't think so.
Isn't it true that you did not sign the dual consent form that Dr. Smith requested when he initially requested it?
I believe that is not true.
Is it your testimony that you did not send an email to Shannon Smith stating that you were unwilling to co-sign the dual consent?
Ever?
Yeah.
I'm not sure, but I don't think so.
Okay, take a look at Exhibit 4 for purposes of refreshing your recollection. Exhibit 4 is an email from Shannon Smith that says, I just received an email from stating he's unwilling to co-sign.
Your Honor, again, move to strike.
Does
It's
that
improper to read it into the record.
This
Does that
predates
refresh
the
your
hearing.
recollection?
This predates the court order, but
Your Honor, again, move to strike. He's allowed to ask the witness to refresh his recollection, but he cannot read it into the record.
Okay. He can't read it, so I will strike that part, but you can ask him the
Does
question.
Exhibit 4 refresh your recollection as to whether or not there was a point in time that you sent Shannon Smith an email stating you were unwilling to co-sign the dual consent?
I don't think so.
Okay, so your testimony is that you never expressed an unwillingness to sign the consent form for Dr. Smith to provide therapy services to Nicholas, correct?
And this is on February 7th?
I asked you, at any point in time, did you express to Dr. Shannon Smith that you were unwilling to sign the consent form?
I don't think so.
Do you believe that you were responsive to Dr. Smith when he would send you requests for signing of documents?
Yes.
Do you believe that you were responsive to Dr. Smith when he would request appointment times?
Yes.
I'm going to ask you to look at Exhibit 8, dates number 1823 in the bottom right-hand corner.
I apologize. The exhibit number? I'm sorry.
Exhibit 8, dates number 1823 on the bottom right.
I see it.
Isn't it true that on June 5th, 2023, Ms. sent a group email to you and Shannon Smith asking for Dr. Smith to see for summer vacation in Ohio?
I'm reading the exhibit, I apologize. I see that that's, that's not really an email that I use, but I see that in the email, yes.
Okay, so on June 5th, 2023, you would agree with me, an email to Shannon Smith and you stating, I let you know that we saw you on Friday, I'm hoping one more session before he leaves to Ohio for summer vacation. He's, meaning you, CC here so you can coordinate, correct?
Again, I don't know, but this is not an email that I really look at, but yes, I believe, yes, that's what it says.
And then on June 13th, you didn't respond to that email, correct?
I don't think so.
Then on June 13th, Ms. another email saying I'm bumping this. Is something set up before vacation, correct?
I see that on the email.
And then on June 13th, Dr. Smith sent an email saying, hi, this week, please let me know what works for you. Do you see that?
I see that.
Did you ever facilitate Dr. Smith before you left for that summer vacation?
I don't recall.
Isn't it true that in January of 2024, you advised Ms. you guys should communicate separately with Dr. Shannon Smith?
I don't recall that specifically, but I believe I said something to that effect, yes.
Take a look at your exhibit binder 204. So it's not going to be the exhibit binders we're just using. And it'll be base numbers 751 to 752.
Can you tell me which letter the exhibit is?
Yeah, it's exhibit CC.
80?
CC, Charlie.
Okay, got it.
So it's 2 of 4.
Yes.
Okay, I have exhibit CC.
Okay, base number 751 on the bottom.
Base number 751 underscore 1?
Yes.
Okay, I see it.
Okay, so the bottom portion is an OFW message from you to Ms. 25th, 2024, correct?
Yes.
And it says, bottom line, appointment with Shannon on Friday because of the past issues with scheduling and the court orders on communication, we should contact Shannon separately for appointments. Do you see that?
I see that.
Isn't it true that the court had authorized you to have group communication with Dr. Smith?
I don't know, but I don't believe so.
Okay, is it true that you had previously had group written communication with Dr. Smith?
I think I facilitated some of that to streamline whatever the issues were. I may have done that previously.
And this said that we should contact Shannon separately for appointments. Why did you want to contact Dr. Smith separately for appointments?
Because when there's contact between mom and me in spaces that are not in our family wizard or text message, my opinion is that mom uses those to get at me, say deprecatory things, and to confuse issues between OFW and general email.
Okay, so it's your position that on OFW, Ms. negative things, won't say negative things to you, but on an email with you and a therapy provider, she will say negative things?
No, that's not my position.
You see on base number 752 where Ms. issues with scheduling, and then in parentheses, in your issue to not allow Shannon to give therapy as he sees fit, and parentheses, is a reason to all communicate. I will continue the joint emails. They were okayed by the court.
I see that it says that.
But again, your position is that you didn't want to be on joint emails with Ms. the therapy provider because it would be an opportunity for Ms. to disparage you.
And to generally confuse the scheduling issues, yes.
Take a look at base number 757.
So am I permitted to add to the previous question?
Don't be your counsel. Can I ask you any questions he wants?
I'm sorry, the base number again?
757.
I see it. Base 757_1.
Ms. Fiore says in the middle on February 4th, 2024. Let me go back. This says weekly communications. Do you see that?
Yes, it says weekly column, yes, short for communications.
And the question was, did you get the joint emails I sent you and Shannon regarding us both speaking with him? Do you see that?
I see that.
And your response was, I saw one email just recently on my Yahoo email from you, but I don't know what it was for. We don't need to start communicating through Yahoo email, and orders prohibit it anyway. If there's some kind of joint session you want to book with Shannon, schedule one or more dates with him, and I will confirm with Shannon separately. Do you see that?
I see that.
And you believe that to be more efficient?
Yes.
Okay. So more efficient for Ms. with Shannon Smith, and then Shannon Smith to email you, and then if the date doesn't work for you to inform Shannon Smith so that he can then inform Ms.
I suppose that could happen.
And that's more efficient than a group email with Shannon Smith saying we want to schedule a joint session.
Question asked and answered.
Overruled.
I think it's more, I think it's in alignment with the court orders, and it avoids some of the interaction issues that come up between mom and me when we're in that space.
You did acknowledge on February 5th, 2024 that you had received an email on your Yahoo email account, correct?
Yes, from a different Yahoo email.
Isn't it true that Dr. Smith was open to the joint communications, to your knowledge, between you, Ms.
I would be guessing a little bit, but I'm assuming because he sent us emails together that he would be open to it.
If Dr. Smith felt that benefit from additional therapy sessions, but they were during your custodial times, is it your testimony that you would bring?
Yes.
Council, are we at a point we can take a break?
Sure.
So go ahead and take a 10-minute break. Thank you. Continue.
Thank you. Before the break, the last question I asked you was if Dr. Smith felt that from additional therapy during your custodial time, would you bring him? And you said you would, correct?
Yes.
Okay, I'm going to ask you to look at case number 735 of Exhibit CC. You see in the middle an OFW message from December 2nd, 2023. And one of her questions was, do you have an issue with one-on-one sessions with Shannon?
Yes.
And your response above is, I do have an issue with it. Do you see that?
I see that.
So isn't it true that Shannon Smith had suggested having the one-on-one sessions?
No, I think it's completely the opposite. He told me that it was completely fine for both to be there until felt comfortable, and also that I felt comfortable.
Okay, so you wouldn't permit sessions, therapy sessions with Dr. Smith without you being present in the room?
For me to be in the room. I would say that I would have an issue with it, but I could see a circumstance where if with it and we had developed some rapport with Dr. Smith, that I would be okay with it.
Your understanding that while in this custodial time, he was having one-on-one sessions with Dr. Smith during that time frame?
I don't know.
Okay, so it was during your custodial time frame that you would not permit one-on-one sessions with Shannon Smith, correct?
I wouldn't say I would not permit it. Would specify what he wanted to do in the office, and I would say, okay, and then Shannon would seem to be okay with that too. That Shannon being Dr. Smith.
Okay, you see the OFW message. Do you have an issue with one-on-one sessions with Shannon? And your response, I do have an issue with it.
Well, in part, I'm advocating for our son.
But my question to you is, you would not permit him to have one-on-one sessions during your custodial time? And you're taking issue with the way I'm asking the question?
That's not the case. I'm saying that I do have an issue with it. I would raise a point of contention, especially, and most of what I'm talking about here is for and trying to make sure that it doesn't get taken out on him for having said it. But I could definitely see a scenario in which, and Dr. Smith were okay with it, that I would okay it. We did have one-on-one sessions with Dr. Monique in my custodial time.
You just said that you didn't want one-on-one sessions with Shannon Smith because something he would tell Dr. Smith could be used against him?
What?
Okay, I didn't understand that. Tell me again why you didn't want one-on-one sessions with Dr. Smith during your custodial time.
Because I'm comfortable with it. And in this Our Family Wizard message, I didn't want to say this because I was concerned that Miss would take it out on.
Okay, and it's your testimony that as of December of 2023, having any one-on-one sessions with Shannon Smith, even during this?
I don't recall. He may have even had a one-on-one session with Shannon Smith during my custodial time.
Well, but according to the OFW message, you had an issue with that, correct?
I said that I had an issue with it. I would not forbid it.
I'm going to ask you to look at Exhibit 7. So you know what? You can stay where you are.
Okay.
Let me see. So you know what? I don't have it on that binder. So Exhibit 7.
Okay. Okay, Exhibit 7.
Yes. Do you see where you made a request of Mr. Friday, tomorrow?
Objection, Your Honor. This document has not been admitted into the record, lack of foundation.
Do you recognize this to be text message communication between you and Mr.
Tell me what exhibit you're on then?
Exhibit 7?
7, okay. See there. Okay, and the question is only whether he recognized it as text messages, so.
Well, he started reading it, so
Okay.
Do you recognize this to be text message communication between you and Mr.
Set to be ruling on the objection. I don't know if I can.
Yes, you have to answer that question.
Okay, sorry, the question again?
Do you recognize this to be text message communication between you and Mr.
I recognize my phone number at the top, but I don't recognize this specifically.
Are you familiar with this text message exchange that you had with Mr.
Can I read through it?
Yeah.
Okay, so the question again, please?
Are you familiar with this text message exchange that you had with Mr.
Not really.
Your Honor, I'm going to need probably a couple of minutes to pull it up in the exhibits that they produced that have already been admitted into evidence then, if that's okay.
Okay. If you want to take the time, huh? Yeah.
Let me ask it this way while I'm looking it up. Isn't it true that there was a point in time where you informed Miss if she kept you would pick him up from school, and she asked you if you would then be taking him to Shannon Smith for therapy, and you said no?
I don't, possibly, I'm not sure.
Isn't it true that you have refused to take additional therapy sessions if it was during your custodial time?
I don't think so.
Moving on to the issues related to eye drops. Isn't it true in 2021, 3 separate medical providers, 2 optometrists, 1 ophthalmologist prescribed eye drops?
At least one gave us a prescription for atropine eye drops in that time period.
Okay, and there might have been others,
Possibly.
and that was for myopia, nearsightedness, correct?
Yes, I think myopia control.
And you would not give eye drops, correct?
I believe I did give him the prescribed eye drops.
After the court entered an order requiring you to do so, correct?
I really don't recall. I'm pretty sure that I gave him the eye drops when prescribed.
Go to exhibit 69. page 11 of that order.
Sorry, I gotta do some housekeeping. Exhibit 69?
Yes.
I see it.
You would agree with me at page 11, paragraph 17, that the court ordered you and Ms. an appointment with Dr. Salim?
Yes.
And it provided that violated, correct?
It says that, yes.
And that the parties would attend the appointment, correct?
This is, you're referring to if both parties cannot or do not want to appear at the appointment, then one can appear remotely for the visit so that both parents can participate?
Right. So both
Yeah.
parties participate. in the
Yes, it says that.
And then it says if the ophthalmologist recommends that administered eye drops, then the court will order the same, correct?
Yes, it says that.
You understand that you had that appointment with Dr. Salim, correct?
I believe so, yes.
And you continue to object to the administration of atropine eye drops, even though Dr. Salim prescribed them for.
I don't know if I would say I objected. I raised concerns that I thought would merit revisiting the eye doctor.
Okay, so this order was November of 2021, correct?
Yes.
Let's go back to exhibit number 2, which is the order that resulted from the January 9th, 2023 hearing. Page 2.
I'm sorry, exhibit again?
Exhibit number 2. And it's page 2 of the actual order.
Exhibit 2. I'm sorry, the page?
Page 2, paragraph 3. Numbered paragraph 3.
I see. Oh, I'm looking at notice of entry. Okay, sorry. Okay. Page 2 of the actual order. Yes.
Do you see where the court order states, as to the eye drops, the court has already addressed this issue. The court ordered the parties to follow the recommendation of Dr. Salim, the child's ophthalmologist. The ophthalmologist recommended the eye drops be used. Do you see that?
I see that.
Isn't it true that you were refusing to administer the atropine eye drops as of January 9th, 2023?
There's a period after our visit in late 2022 when Dr. Salim said that he should discontinue at least for a while because his eyes were permanently dilated from the eye drops. So I don't know if that falls in that time period, but other than that, I was administering the eye drops daily as per the ophthalmologist's recommendation.
Or do you recall that Ms. that issue with the court requesting an order that you administer the eye drops?
I think I recall that.
And the court in fact said it is ordered that defendant comply with the recommendations of Dr. Salim, which currently are that the minor child receive the eye drops that are at issue. Do you see that? Bottom of 2 going into page 3.
I see that. I don't know if that was Dr. Salim's recommendation at that exact time.
That's what the court order said it was, though, correct?
It says, the court order says that, yes.
And that was the second time that this the issue of eye drops to the attention of the court, correct?
I would dispute the word have, as in implying necessity, but she brought multiple motions about that, I believe.
Isn't it true that as of May 18th, 2023, the ophthalmologist said that the treatment was working in terms of the eye drops?
Objection, lack of foundation, calls for hearsay.
Overruled.
Sorry, the question again?
As of May 18th, 2023, is it your understanding that the ophthalmologist believed that the atropine eye drops were being effective for Nicholas?
Yes, I believe so. I apologize. I'm guessing a little bit, but I believe so.
I'm going to ask you to look at base number 1157 of Exhibit CC. Sorry, DD, which is in binder 3 and 4 of your binders.
So, this is a defendant binder?
Yes.
Okay. Binder 3, exhibit DD.
Yeah, page number 1157.
Page number 1157_1. Yes.
Yes.
Okay.
On August 11, 2023, you sent a text message. This is not OFW, correct?
Yeah, this is not OFW.
You sent a text message to Ms. You didn't book Nick's regular dental checkup with your unnecessary fabulous dental plan, did you? Question mark. You see that?
I believe so, yes.
You sent that message, correct?
I believe so.
And then you continued, did you resolve the $1,000 the fifth dermatologist you unnecessarily hired said to them? Do you see that?
I see that.
You sent that, correct?
I believe so.
You then said, 5 minutes later, here's the deal. I'm not asking for reimbursement of the school supplies. I'm not going to ask for reimbursement of anything anymore. You see that?
I see that.
And then down in the text message, you say, clearly you and your attorney have some serious issues with the truth. Anyway, I will pay all the medical expenses. I will pay for classes. I will get a regular dental provider in town, and I'll pay the cash price. If they're all pretty similar, you can choose. Do you see that?
I see that.
You then say, Nick will go to Dr. Salim as usual for ophthalmology. Do you see that?
I see that.
And you sent these, correct?
I believe so.
You say Dr. Salim to check up on or recalibrate these atropine drops because they're now worse than mine. He has daily issues with light sensitivity and nausea, vomiting, and none of that shows any sign of improvement. Do you see that?
I see that.
And then you say, again, you and your attorney have some serious issues with telling the truth, especially in Nick's vision medical history. Did you say that?
I believe so, yes.
You were referring to Ms. bringing motions to the court related to atropine eye drops?
In part, yes.
You're aware that the court issued a communication protocol as a result of the October 2021 hearing?
Yes, the court installed the the communication protocol that the parenting coordinator made, I think, with a slight adjustment or something.
look back at Exhibit 69. This is the November 1st, 2021 order that resulted from the hearing on October 13th, 2021, correct?
Yes.
At page 9, it says protocol summary.
Yes.
It says weekly co-parenting matters are to be addressed by the parties through OFW, correct?
Yes.
And then in terms of communication, at paragraph E, it says, after the weekly OFW communication, all, in capital, communication stops for the week, with the exception of urgent situations, emergency situations, or time-sensitive matters related to the child's schooling or extracurricular activity. Do you see that?
I see that.
And then at G, it says, emergency situations are communicated in a manner appropriate to the situation and in keeping with the mutual behavior order of June 3rd, 2020. Do you see that?
I see that.
Okay, we just looked at the text messages in your exhibit CC at page number 1157. Would you agree with me that that text message violated the communication protocol?
Objection calls for a legal conclusion.
I don't know, but I don't think so. I'm also not sure if the communication protocol was still in force at that time in whole.
Was there a court order that ever modified or rescinded the communication protocol?
My recollection is there was a court order that deemed the communication protocol in part or in whole to be unenforceable.
Okay, so you made a determination that it was okay under the communication protocol because it was either deemed in whole or in part unenforceable to say things such as your unnecessary fabulous dental plan, the dermatologist you unnecessarily hired, you and your attorneys have some serious issues with the truth. Again, you and your attorneys have some serious issues with telling the truth. You found all that to be acceptable communication, correct?
I thought it was necessary.
That was an emergency circumstance?
I think it was time sensitive relating to payment and medical appointments.
There's no reference to an appointment in the text messages we just looked at on August 11th, is there?
That's not correct.
Okay, there's a date, there's a reference to an impending medical appointment?
There's a message, at least about Dr. Salim for ophthalmology, and a comment that I'm going to reschedule the appointment with Dr. Salim to check up on or recalibrate the atropine eye drops. And there are messages about scheduling for a dental provider, and there are messages about expenses that I'm not certain, but could be time sensitive.
As you sit here today, can you point to any reason why this could not have been communicated through OFW during the weekly communication?
The same response I just gave. I apologize. I'm not allowed to add, correct?
There's no question pending.
Okay.
Moving on, do you remember that there was a court proceeding on September 13th, 2022, where you stated on the record that you consented to getting a flu shot for that year?
Yes, yeah, I believe so.
Isn't it true that you then refused to provide consent to the pediatrician for him to have a flu shot?
I didn't refuse, I don't know, it's the characterization of the question. I didn't refuse to provide consent. I think what I said is that Mr. take the order and get a flu shot.
Okay, so you were aware that there was a court order that get the flu shot for that year, correct?
Yes?
Take a look at base number 1026 in your exhibit CC.
Page number again?
Base number 1026.
Yes. Well, these are all _1. I'm assuming that it doesn't make any, I just don't want to keep saying it every time that it's _1.
Yeah. If it's a different underscore, I'll make a record of that. But
Sure.
when I refer to the base numbers of your exhibits, they're all _1 unless I say otherwise. Fair?
Yes.
Okay. So base number 1026. Do you see where Ms. message on November 9th, 2022, saying call St. Rose P. Henderson, pediatrics, correct?
Yes.
And confirm dad is okay with flu shot. Let me know after. Do you see that?
Yes.
You responded, you know my position on the flu shot. I think it's net harmful to this point, and I don't want any part of it. As far as I know, it's also usually grown in chicken eggs. I don't know if you're still raising. I agreed to withdraw my objection to it for this year on the record. You see that?
Yes.
So even though the court had ordered that the flu shot for that year, and the court order expressly stated that you consented to it, you would not call St. Rose Pediatrics of Henderson and inform them that you were okay with him having a flu shot, correct?
No, I did not call to tell them that I consented to the flu shot.
Even though you told the court that you consented, correct?
I think I said I withdrew my objection to it and that Mr. take the order and get the flu shot. I think I said that in the message also.
Your Honor, I'm going to ask the court to take judicial notice of the September. I'll have to find it because I lost that page. Here it is. September 13th, 2022 order where it says, quote, defendant on the record consented to flu shot this year and plaintiff can therefore take Nicholas for said flu shot. That's part of the order, end quote.
All right, I will. My copy of Exhibit C that I'm bringing up does not go as far as you said. I don't know if I'm missing something.
This is fourth.
Double C,
line
Your
or
Honor,
CC.
double C.
Yeah, it's, double C, I'm on that. It only goes to page 923. 923.
I think that's
So
just the
maybe
next
it's
volume.
different
Those are your
version?
exhibits.
Yeah.
I'm just confused. Point me in the right direction.
You're on the digital exhibits, are you not?
Yes. With the physical. Were there more pages added in the physical one?
No.
I think we were in double D just before that, if that helps.
Was that
I'm not
double
sure.
D? Oh, that is DD. That's
That might be why, Judge.
That's why.
Okay. I thought I was confused. Okay, and you said which page on the, Oh, it's 10 something, right?
1026.
10:06. This is one of the reasons why we have an order regarding where they're supposed to communicate. These are text messages?
Yes.
Oh. And are these admitted?
These were stipulated.
Okay.
Mr. Remember on November 21st, 2022, when you walked out of a scheduled dental appointment because you didn't want to pay the $190 that was needed for the filling?
I recall walking out. I would dispute that was the reason.
And what was the reason you walked out then?
No one there could actually tell me the cost. They had sent us an invoice for over $900, and nobody at the office seemed to be sure why. And when I was at the office, the secretary, or so one of the office personnel contacted Ms. For payment, and she declined. So I was concerned that something was not correct with the plan or the price. I really wasn't sure what was going on.
So you left,
Yes,
even though, correct?
yes,
And Ms. sent you a message at base number 1041 saying pay the dentist.
I see that.
And you said, I'm working, I'm not, oh, sorry, she said, I'm working, not answering again or paying, I'll reimburse. You're stalling the dentist is annoyed. She said it's getting late. But what happened at the dentist and why you walked out in OFW, memorialize it, please. We'll need it. Do you see that?
Yes,
She would reimburse you for half of the dental expense, correct? I'm not answering again or paying, all reimburse.
yes, I think that's what that means, yeah.
I'm gonna go to exhibit CC. Case number 722.